Welcome this afternoon to the Going Global sponsored webinar with our immigration specialist, Mark Rhodes. This afternoon, this is specifically for staff, even though all the text, all the content that you're about to take advantage of, be privy to, is applicable to the students you serve. I think you'll learn a lot today. So this is Marianne Thompson, the president and founder of Going Global. I'm joined this afternoon by Mark Rhodes, who's a senior partner at McCandless Holton. But let me tell you just a few things before we get started. The presentation this afternoon will be recorded. So if you'd like to hear it again or you'd like to share it with colleagues, you will find the link on the Going Global platform and links to prior presentations that Mark and his associate Crystal Malik have done in the past, specifically on green cards, H-1B, OPT, etc. Throughout the presentation, you're welcome to send in questions via the chat box, and we'll try to get to as many of those questions as we can. The presentation itself should last 30 to 40 minutes. We'll try to get to some questions then. What questions we don't get to, you're welcome to send an email to Mark or his colleague Crystal, who's just on a plane today and not able to join us, and they'll be happy to get back to you with your specific questions if we don't have time to answer them today. I do want to remind you that Going Global hosts our own training sessions several times a month. That's listed on the Going Global site as well. Specific sessions for students, specific sessions for staff. We also are very happy to host private sessions for groups of staff. The Going Global content, most of you represent your career centers, but the content is just as relevant for study abroad, clearly international students, international programs, alumni services. So we're happy to do a presentation for all of these stakeholders privately upon request. Just write to me at President and Going Global. Very happy to set this up. I'll repeat it again, but I do want to point out that our next webinar that Mark and Crystal will be hosting, thanks to requests from you, is specifically set up for employers. We've had over 10,000 attendees to these presentations that Mark and Crystal have hosted over the course of the past 2 years, and staff came back to us repeatedly and said, gee, this is great information. I wish we could share it with our employers. So although employers aren't Going Global's customer base, they're yours. And so with our compliments and Mark and Crystal's expertise, we will be hosting that on March 19th. Because your customers don't have direct, or the folks you're recruiting with, access to the Going Global platform, you will find a link that goes right to a sample invitation where we've embedded a registration link so your employers can directly register for that presentation once again on March 19th. So let me begin the presentation by sharing a little information about Mark. Mark is a well-recognized immigration attorney with, as I told you, the McCandless Holton law firm and their immigration practice group. He specializes in working with companies and universities throughout the United States, processing and how to successfully process, most importantly, thousands of work visas and green card applications each year. Mark frequently collaborates with universities to counsel staff and students on the latest guidelines for successfully navigating the U.S. immigration process. Mark has been repeatedly recognized as one of the best lawyers in America for immigration law. I got introduced to Mark because he is a repeat presenter at all the NACE conferences. So my guess is he is a familiar name to you as well. So with that, it's my honor and great pleasure to now turn this over to Mark Rhodes to share the latest information for you on counseling and guidelines for students who want to pursue ways to work in the United States. Mark, off to you.
All right, well, thank you very much. My name is Mark Rhodes. As Marianne said, I'm an immigration attorney. What that means is that I work with companies all over the United States. I help them process work visas and permanent resident green cards for international employees. My office is based in Richmond, Virginia. And although I'm based in Richmond, we have 10 immigration attorneys. We work with companies all over the country. Coast to coast, we work with companies anywhere from organizations that have thousands of employees all the way down to very small startups with only 1 or 2 employees. What I'm going to try to do here in the course of the next 40 minutes or so is to give you an understanding of how the immigration process works for international students. Because in working with all of these companies all over the United States, one thing that I can promise you, if you're in a career services profession, most companies, most employers have no idea how the immigration process works. The White House doesn't know how the immigration process works. And because of that, because employers don't understand the process, it makes them sort of reluctant to recruit international students. And I know that and I've been working with university career services offices all over the country for a very long time. Many career services folks have no idea how the process works, and it's very frustrating to try to counsel international students who are out in the job market if you don't have a baseline understanding of how the immigration process works. So that's what I'm going to do over the course of the next 40 minutes is give you an understanding about how an international student in the United States moves from being a student, graduating, getting a work visa, and staying in the United States after graduation. And I'm going to be throwing an awful lot of information at you over the next 40 minutes or so, probably more than you can absorb. It's sort of mind-numbing even for me to talk about it, much less listen. So I think some of the most important information is right up here on the screen right now, which is my contact information and the contact information for Crystal Malik, who's one of my law partners. And this is helpful information because we'll answer questions for free. So if you walk out of this webinar this afternoon and you forget everything that you have learned, or you doze through the course of it and you never learned anything, keep my contact information. You can give me a call, send me an email if you have a particular question, or if a student comes into your office, asks you something that you don't understand, send me an email, give me a call. I'm happy to answer your questions, and I do this for free. And my office fields hundreds and hundreds of questions regarding the immigration process every single year. We don't charge for it. So for those of you who are in university, college, career services offices, this is very helpful information to have. So with that, let me give you a little quick introduction to how U.S. immigration law works. There are basically, if somebody wants to be in the United States and they want to be here legally, there are basically 2 ways that they can be here. One is on what's called a temporary or a non-immigrant visa. There are non-immigrant visa categories that run from the letter A all the way down to the letter V, as in Victor. Every letter of the alphabet has a visa category associated with it. In international, at universities in the United States, far and away the most common visa for international students called F1, F like Frank. And that's what we're going to concentrate on here today is the F1 visa. We're going to follow that up with a discussion of H1B. So of all those lettered categories, A to V, most of them the students never going to qualify for. So what we're going to focus on are the ones that students most likely are going to want to focus on, and that is the F1 and something called optional practical training, and then the H1B. Another way that people can be in the United States legally, other than a temporary non-immigrant visa, is using a permanent resident green card. There are green card categories. Basically, to get a permanent resident green card, the 2 categories that are most common are either based on family relationships or based on employment. So there are ways to get a green card through family members. there are ways to get a green card through employment mechanisms. I'm not going to spend a bunch of time talking about green cards. That's going to be a topic for a whole different day. We have limited time. So what I really want to do today is to focus on the temporary options that allow an international student to stay and work in the United States after graduation. And I've been practicing immigration law for about, I don't know, about 30 years. And in that period of time, I've worked with thousands of international students. And in my experience, about 95% of every international student in the United States, if they want to stay and work in the US after graduation, they're going to follow the path that I have up on the screen right now. And that path is as follows. And recognize this is what I'm focusing on here is work visa options after graduation. There are ways that an international student can work while they are in school, such as for a summer internship or a practicum or something like that. I would encourage you to talk to your international student advisors if you have questions about how an international student can work during their degree program. What I want to focus on are the ways that an international student can stay and work after graduation. And here is the typical path that I find, as I said, with about 95% of every international student. Step one, because the most common visa for international students is F1, every F1 student in the United States is eligible for what they call optional practical training, OPT. Optional practical training will allow an international student to stay and work in the United States after graduation for up to 12 months. They can work for any employer doing any job as long as the job is related to their degree program. And OPT is the greatest way for a student to get their foot in the door with an employer, because the employer doesn't have to do anything. The employer doesn't have to file paperwork with the government. They don't have to pay any fees to anybody. All the employer has to do is decide they want to hire this international student. And as long as the international student has an OPT work card, that I'm going to talk about in a second, that student can go to work for that employer anywhere in the country doing any job, as long as the job is related to their degree program. So step number one for every student is to get optional practical training. Every F1 student gets 12 months. If the F1 student graduates with a STEM degree, science, technology, engineering, or math, that student will get an additional 24 months of optional practical training for a total of 36 months of work authorization in the United States. While the student is working using that optional practical training, they're going to want to talk to the employer about pursuing an H-1B. H-1B is the most common work visa in the United States, and it is the work visa that almost all international students will want to get while they're working using their optional practical training. So the first step to staying and working is getting optional practical training. Step number two is to talk to the employer about pursuing an H-1B. And it's typically while the student is working using the H-1B. H-1B is going to be valid for a total period of 6 years. So they get their initial period of optional practical training, then they get 6 years of work authorization using OPT. While they're working using OPT, that's when they're going to want to pursue a permanent resident green card. And if you have students who come in and ask you, I don't want to do H-1B, I hear about this lottery, I hear it's very expensive, can't I just get a green card? The answer is it will take far longer for that student to get a green card than they have available on OPT. So what they're going to want to do is forget about green cards initially when they're trying to find employment in the United States, because it can take years to get a permanent resident green card. They're not going to be able to have a green card in their hands by the time they graduate and by the time they want to go to work for an employer. So what they first need to focus on are the temporary ways. And if you have a student who insists on pursuing a green card, tell them to give me a call, send me an email. I'm happy to answer their questions. You don't need to mess with that. Encourage them instead to focus on the temporary options available to stay and work, and that is F1 optional practical training, followed by the H-1B. Once they get onto that path, then they can consider the permanent resident green card. So with that long-winded introduction, let me pop into, there we go. So the first step, as I said, for an international student to stay and work after graduation is optional practical training. Optional practical training allows them to work for up to 12 months for any employer doing any job. But in order to take advantage of optional practical training, they must get a work card. The work card is called an employment authorization document, an EAD. So you're going to hear all kinds of students talking about their OPT EAD. That's just the work card that allows them to go to work. It's a card that looks just like a driver's license. It will have a begin date that will be after their graduation, and that card will end 12 months later. If they are in a STEM degree program, they'll get that additional 24 months, but let's look first at the initial 12 months. In order to take advantage of OPT, they must get this work card. The student cannot go to work until they have the card. If they go to work before they have that card in their hands, they are deportable from the United States. If they are working for an employer and the employer puts them to work before they have that card in their hand, the employer can be fined by the federal government. No employer wants to take that risk. So what you need to encourage your international students to do is to apply as early as they can to get that work card. And there is a window to apply for this card. And you should encourage them to work with the International Student Office at your college or university, because the International Office can help them apply for the card. They can apply for the card once they're in the last semester of their degree program. And the window to apply for the card is 90 days before graduation or up to 60 days after graduation. So what I usually encourage students to do is to go back to their dorm or their apartment, find a calendar, circle the graduation date, count back 90 days. That's the first day that they can apply. They don't have to have a job offer in order to apply for this card. They don't even have to have started looking for a job yet. They're automatically eligible to apply for that card as long as they are within 60 days or within 90 days of graduation. Now, as I said, they can apply up to 90 days before graduation or up to 60 days after graduation. And I get students ask me all the time, well, why don't I hold off? Because right now it's taking the Immigration Service 90 to 120 days to process that work card application. And if I wait until after graduation, then I can stay for those months in the United States while they're processing the card. So why don't I do that? And the answer to that is you can't work until you have the card. If you wait until after graduation and you apply for that work card and it's taken the Immigration Service 90 to 120 days to process, you're going to be well into the fall before that card is in your hands. You can stay here in the US, but you can't work until you have the card. If you are going to lose job opportunities if you delay applying for the card. So I encourage international students always to apply for that card as early as they can. And they can apply as early as 90 days before graduation. There is no reason to delay. So you apply for the card is issued, it will be effective anytime within the 60 days after graduation. So when they apply for the card, they tell the Immigration Service when they want the card to be effective, and it can be effective anytime within the 60-day period following graduation. Once that card is effective, then they can go to work. If they get a job offer and the employer wants them to go to work before the effective date of the card, they can't do it, and there is no way to change that effective date. So it's very important for them to think about when they want that card to become effective. If they have job offers before they graduate, they will obviously want the card to be effective as soon after graduation as they can. If they don't yet have a job offer and they want to delay the effective date of the card to give them additional time to look for employment, that's perfectly fine, but that's going to be an individual decision for each student to have to make. So once they get that card in their hand, they can go to work for any employer doing any job anywhere in the United States. If they have a STEM degree, if they graduate with a science, technology, engineering, or math degree, they get that additional 24 months of optional practical training, allowing them to work for any employer doing any job for a total of 36 months in the United States. While they're using their OPT, they can work for multiple employers. They can work for one employer. They can work for concurrent employers. They can jump from employer to employer as long as they have that work card. They notify their foreign student advisor about where they are working, and they're perfectly fine to stay and work in the United States for the duration of their optional practical training. But when they have that card, whether it's for the 12-month period or for the 36 months for STEM extension, they all know that there's a clock ticking. And that clock is the end of that OPT period. And when their optional practical training work card expires, whether it's 12 months or 36 months, they're going to have a choice. They have one of two choices to make at the expiration of that card. Either depart the United States, they can stay in the United States for 60 days after it expires, but then they're going to have to depart the United States. Or they can change to a longer term work visa that allows them to stay and work in the United States following the expiration of their optional practical training. And the most common longer term work visa that they're going to want to try to secure is called the H-1B. So let's talk about this H-1B. People hear a lot about the H-1B work visa. So let's talk about how the H-1B works. It is the most common work visa in the United States. To qualify for an H-1B, there are three requirements. Requirement number one, the student has to have an employer. Okay, when you did the OPT, they didn't have to have an employer. They didn't even have to start looking for a job yet. They could file for the OPT on their own. Not so with the H-1B. Only a U.S. employer can file an H-1B petition. The student cannot apply on their own. So step number one, you have to have an employer. Step number two, the student has to have at least a 4-year U.S. bachelor's degree or the foreign equivalent of a 4-year bachelor's degree in the United States. So if a person is in a bachelor's degree program now, they don't yet qualify for the H-1B because they don't have a degree yet. If somebody is in an advanced degree program, like a master's or a PhD or a JD for a lawyer, they already meet this requirement because they already have a degree. They will already have a U.S. bachelor's degree or the foreign equivalent of the U.S. bachelor's degree. So requirement number one, they have to have an employer. Requirement number two, they have to have at least a 4-year U.S. degree or the foreign equivalent of a 4-year degree. Requirement number three, and this is the requirement that is the single largest basis for H-1B denials, and therefore is something that has to be closely reviewed. And this requirement is that the degree that the student has to relate closely to the job. Said differently, the job has to require the type of degree that that student has as a minimum entry-level requirement for that position. So the H-1B is actually, it's called a specialty occupation work visa, meaning that it's only for occupations that require a specialty degree in order to do the job. Like an accountant has to have an accounting degree, or a civil engineer has to have a civil engineering degree, or a lawyer has to have a law degree. The H-1B is for jobs that require a specialty degree in order to pursue the occupation. And again, this is the biggest reason why the Immigration Service denies H-1Bs. And in the previous Trump administration, H-1B denials started out at about 4%. By the end of it, it was up to around 25% denial for H-1Bs. And the reason was that the Immigration Service would get H-1B application. They would look at the job duties. They would look at the student's degree, and they'd say, we don't think that this job requires this kind of degree. And it's a very subjective standard. So what I typically do, and I get students ask me all the time, well, I have a degree in this, and I want to do this job, and will it relate, and am I going to qualify? What I tell the student and what I tell employers to do all the time, at my office, we've probably processed, I don't know, 50,000 H-1Bs over the years. We have a very, very small denial rate. And part of the reason is we insist that people go through this exercise prior to filing an H-1B petition. And that is, get a bullet point listing of the job duties. So most companies have these bullet point job duty listings. Get that listing. And then pull out the student's degree transcript. And I want the student to tell me the courses that the student took that trained the person to do each of the duties on that bullet pointed job duty listing. And if they can make a very strong correlation between their coursework and the duties of the position, they'll have a very strong H-1B application. If they cannot make a strong correlation between their coursework and the duties of the position, they might want to look for a different opportunity because they're going to have a hard time qualifying for H-1B. So those are the three requirements. You have to have an employer, you have to have a degree, and the degree must relate closely to the duties of the position. Now, I do a lot of these kinds of speeches to groups of employers, and one of the questions I always get from an employer, they always say, well, look, what I always hear is, I mean, I hear what you're saying, got to have a degree has to relate to the job, but I hear that I have to prove that there were no qualified U.S. workers for this position before I can sponsor an H-1B, and the answer to that is totally false. There is no requirement that an employer show that they cannot find a U.S. worker. There is no requirement that the employer show that the international student was better qualified than U.S. workers. It's simply a matter of, does the individual have a degree? Does the job require the type of degree that this individual has? If they do, they can file for an H-1B. No requirement to advertise for U.S. workers. So what happens? So the student they graduate, they get their optional practical training, they go to work for either 12 months or the 36 months for the STEM extension. They apply, they talk to the employer files the H-1B petition. The Immigration Service reviews it and concludes that the duties of the position relate to the degree that the student has. They approve the H-1B. That student can actually change their status right here in the United States. They do not have to depart and go back to their home country. They can change right from F1 to H-1B here in the United States. So what does that approval get them? What the approval gets them is 3 years of work eligibility in the United States. They can work using that initial approval for up to 3 years. When they are within 6 months of expiration of that initial approval, they can apply for an additional 3 years for a total of 6 years in H-1B status. While they're working using the H-1B, they can only work for the employer who sponsored them for the H-1B. They can't work for anybody else. So a student can't go to work for the employer that sponsors them Monday through Friday, and then on weekends go work at Starbucks to earn extra money. They can only work for the employer who sponsored them. They can only work in the job described in that H-1B petition. But that does not mean that they are stuck with that same employer for all 6 years. They can change and move to a different employer if they want to, but if they do, the new employer will have to file a new H-1B petition. Well, why is that if they already have an H-1B? Well, because every time the person changes jobs, the Immigration Service wants to review to make sure that the new job requires the type of degree that that student has. So it could be that when the student graduates, they go to work for employer A. Employer A files a 3-year H-1B petition. 1 year in, let's say the student decides, I hate employer A, I want to go to employer B. Employer B will file a 3-year H-1B petition. And when they file it, the government is going to again look to see whether the duties of the new job require the type of degree that the student has. So every time they change jobs, and they can change jobs as much as they want, but each time the employer is going to have to file a new H-1B petition. That does not give them 6 additional years. They get a 6-year period no matter how many employers they jump around to. So in the example I gave a second ago, they go to work for employer A, who files a 3-year H-1B. 1 year in, they jump to employer B. Employer B files a 3-year H-1B. They will have worked for employer A for 1 year. They work for employer B for 3 years. That's a total of 4 years. They only have 2 years remaining. And so it's 6 years no matter how many employers they jump around to. So when I do these things, these kinds of presentations to employers, one of the first questions I get is, okay, I get it. I can file an H-1B petition. What's it going to cost me to do this? And there are basically 2 categories of cost, and it's very important for international students to understand what these costs are, because there's a lot of misinformation about how much an H-1B costs. There are basically 2 categories of cost. One is an attorney fee, my fee, or a different immigration attorney who files the application. Most organizations do not have in-house expertise to file an H-1B petition, so they hire an outside attorney like me. In our office, we charge $3,100, $3,100 to prepare an H-1B petition. The second category of cost is the government filing fee. And there are a number of filing fees associated with the H-1B. I've listed them up here on the screen. The short answer for what the filing fee is, if the student goes to work for an employer that has 25 or fewer employees, the total filing fee is $2,010. If they go to work for an employer with more than 25 employees, it's $3,380. So my fee, $3,100, and then the government filing fee. You add that all together, and you're looking at, if he goes to work for, or the student goes to work for an employer with more than 25 employees, you're looking at a little over $6,000, $6,500 to file an H-1B petition. And I can tell you, having done this for 30 years and processed 50,000 or more H-1Bs, these costs are not an impediment to an employer pursuing H-1B. Most employers view these costs just as a recruiting expense. They spend a lot of money recruiting to get talented employees. Sending recruiters to college campuses, advertising in various media, all that costs money. They view this merely as another recruiting expense, and for most employers, it is not a concern. And it's very important for the employer and the student to understand that these are truly employer expenses. They cannot be paid by the student. They cannot be reimbursed by the student. They are 100% employer expenses. But in all the years I've been doing this, I can count on one hand the number of employers who decided not to proceed because of these costs. This is not a concern. What is a concern is what's up here on the screen right now, which is the H-1B quota. The quota is a major concern for many employers. And here's how the H-1B quota works. So every single year, even though the H-1B is the most common work visa in the United States, it is limited to 85,000. The government can issue 85,000 new H-1Bs every quota year. The quota year begins October 1 of every year, and it ends September 30 the following year. So the quota year that we're in right now started October 1 of 2024, and it will end September 30 of 2025. So we're 5 months or so into the quota year. On October 1, 85,000 new H-1Bs became available. And I emphasize new because the quota only applies to individuals applying for an H-1B for the first time. Once the student gets their first H-1B, they never have to worry about the quota ever again. So they can change employers without having to worry about the quota, file an H-1B anytime. If they get to the end of their first 3 years, they want to file for an extension, don't have to worry about the quota, they can go ahead and file the H-1B petition anytime. It only applies for the very first time that a student is getting an H-1B. So on October 1, 85,000 new H-1Bs become available. That quota of 85,000 is divided into two buckets. There is one bucket that is available just to individuals that have a U.S. advanced degree, and that is any degree above a bachelor's degree. So it can be a master's, a PhD, an MD for a doctor, a JD, any degree above a bachelor's degree from a United States college or university qualifies the individual to be in the advanced degree quota. That advanced degree quota is 20,000. Everybody else is in the regular quota. The regular quota of 65,000. So if somebody has a master's degree from Canada, they're in the 65,000 quota because it's not a U.S. advanced degree. If they have a PhD from China, they're in the 65,000 quota because it's not a U.S. advanced degree. If they have a bachelor's degree from the United States, they're in the 65,000 quota because it's not an advanced degree. And I get students who get very worked up about wanting to make sure they get an advanced degree lottery number. Well, that doesn't make any difference. All the student wants is to get an H-1B quota number, whether they get the quota number in the advanced degree quota or in the regular quota. And I'm going to talk for a second about how this quota thing works. Because here's the deal. We are, 4 or 5 months into this quota year. 85,000 new H-1Bs became available on October 1 of 2024. The government can continue to issue H-1Bs for as long as that quota lasts. Anybody have any idea how many H-1Bs are available right now? None. And in fact, all H-1Bs for the quota year were taken on October 1st, the very first day that they were released. And the reason that they were all taken on October 1, the very first day they were released, is because employers can pre-file to get an H-1B. So let's talk about how the employer can pre-file to get one of these H-1Bs, because it's very important for international students to understand how this process works so that they can help employers understand what the employer needs to do to get one of these H-1B quota numbers. So up here on the screen right now is the quota year. It's the shaded area running from October 1 to September 30 the following year. 85,000 H-1Bs become available on October 1. But look back to the left, back in March, because every year in March, the government opens up what they call a pre-registration period, where all employers who want to file an H-1B petition on behalf of an employee must register to try to get an H-1B quota number. Every year in March is when the registration period takes place. It takes place on different dates in March every year. The government recently announced that this year, the registration period is going to take place from March 7 to March 24. During that roughly 3-week time frame, every employer that wants to file an H-1B petition has to file a registration application with the Immigration Service. It's a fairly basic registration application. They'll put information about what the job is. Don't put information about the person's degree other than whether they have an advanced degree. Just basic information about the company, basic information about the employee's name, date of birth, country of birth, that sort of thing. So we submit this pre-registration application during the registration period, anytime between March 7 and March 24. Once all the registrations are submitted during that time frame, and the government cuts off the registration period on March 24, they will then assemble all the registrations that were submitted, put them in a big old pile. And out of that pile, this past March, during the registration period, the government received over 500,000 registrations for the 85,000 quota. So they assemble all 500,000 into a big pile. The first thing they do is they look through to see which applications were submitted for individuals with a U.S. advanced degree, because that's going to be in the U.S. advanced degree quota. So they segregate out all of the cases that were filed for individuals with a U.S. advanced degree. And let's say it was 100,000 that were submitted for the advanced degree quota. So they take that 100,000 and they first count out 20,000, because that's the advanced degree quota. They then take the remaining H-1B registrations and put it back in the big old pile, mix it up again, and then they count out 65,000. So if somebody has a U.S. advanced degree, they get 2 shots in this H-1B lottery process. They get the first opportunity with the 20,000 advanced degree quota, and then they get a second opportunity in the regular quota. So individuals with a U.S. advanced degree get 2 opportunities in the H-1B lottery process. The government will run this lottery process from the end of the registration period up through April 1. On April 1, they will notify everybody who was selected in the lottery. So if you were one of the lucky 85,000, you will be notified by April 1 whether your case was selected in the lottery. If the case was selected in the lottery, then the student will have 90 days to apply for the H-1B petition, or the employer will have 90 days to submit their H-1B petition. So that's basically how the H-1B lottery process works. So let's look at it in practice. Let's look at 2 scenarios. Let's assume that a student has an employer willing to sponsor them even before they graduate. So they have a job offer and they're ready to go. The other more common way is if the student does not have an employer willing to sponsor them yet, and they need to find a job after graduation. So scenario number 1, the student has an employer offered him a job and is willing to proceed with the H-1B registration process even before graduation. So let's say the student graduates in May. The registration period takes place in March, which is before graduation. Can an employer file a registration before the student has the degree required for the H-1B? And the answer is yes. You can file a registration before you have the degree. They can't file the H-1B petition if they're selected in the lottery until they actually have the degree. So let's say a student wants to rely on the advanced degree that they're going to get in May, but they don't yet have it yet. They don't yet have it. So the employer files the registration in the registration period in the advanced degree quota. If the case is selected, they'll be notified by April 1. They can't file the H-1B petition yet because the student doesn't yet have the degree. They'll get the degree in May, which is within the 90-day time frame after April 1. Once they get the degree, then they can file the H-1B petition. Assuming that that H-1B petition is approved, it will be effective on October 1. It can't be effective earlier than October 1 because October 1 is when the quota is released. So even if the student has an employer willing to sponsor them, to file an H-1B, for them even before graduation, they still have to get optional practical training in order to work between graduation and October 1 when the quota is released. So every international student, even if they have a job offer before they graduate, needs to get that OPT to make sure they can go to work after graduation to bridge them until October 1 when the quota is released. Well, let's say the more common scenario is that the student does not yet have a job offer and doesn't have an employer yet who's willing to sponsor for H-1B. So they get to graduation in May and they want to go to work. How do they go to work? They go to work using optional practical training. Every student has to get OPT. So the student goes to work using their OPT. They get up to October 1 when the quota is released. They don't care because nobody filed for them anyway. They get up to January 1. Guess what they're going to be looking at? They're going to be looking at the registration period in the March after they graduate. So they go to work using OPT. They get up to January, February. They start talking to the employer about filing in the H-1B pre-registration period to make sure that they give themselves the best chance to get one of those H-1B quota numbers. And I usually tell students and employers to contact me sometime in February to start to get this process underway so we can get the questionnaires and whatnot ready to go. In my office for the registration, we charge $500. The government filing fee for a registration is $215. So we go ahead and we submit the registration. If the case is selected in the lottery, we'll be notified as of April 1. We can then file the H-1B petition right away because the student will already have their degree, and we can wait for the Immigration Service to approve that case. It will be effective as of October 1. The student will be able to work using their OPT for that entire time. So let's say that a student is not selected in the lottery. They have their optional practical training. Are there other options available other than the H-1B that may allow them to work in the United States? And the answer is not many. There are some options available, actually excellent options available for citizens of the countries across the top of the screen here: Canada, Mexico, Chile, Singapore, Australia. There are great options other than the H-1B. If you are faced with a student from one of those countries and they have questions about what options may be available other than H-1B, tell them to send me an email, give me a call. I'm happy to talk them through the issues. Another option that may be available is the L1. That's for individuals who work for multinational corporations, corporations that have operations outside the U.S. and operations inside. If a student goes to work for a multinational corporation, they first have to work outside the U.S. for at least a year. Then they can transfer back into the U.S. using the L1. So that's an option for individuals working for multinationals. The E-visa is an option available to citizens of certain countries that have treaties of trade and commerce with the United States. If a student is from a country with a treaty of trade or commerce with the United States, China's not one, India's not one, so they can forget it. But if a student is from a country with a treaty of trade and commerce with the U.S., they may qualify for an E-visa. And you can actually encourage students to Google E-visa treaty countries to see if their country is on the treaty list. if the country is on the treaty list, then that student could go to work in the United States for a company owned by citizens of their country. So, for example, Germany is on the treaty list. A German citizen can go to work in the United States for a company owned by German citizens. So if a company is owned by Germans, a German student could go to work for that company using an e-visa. It's also an excellent way for students who are entrepreneurs to open up their own business. If they're on the treaty list, they can actually start their own business using the e-visa category. My office processes many e-visas. But those are about the only options. You're either from one of the countries on the top of the screen, you go to work for a multinational, or you're from one of the treaty countries. With those exceptions, what most students do who are not selected in the H-1B lottery, they either re-enroll in school or they head home. And this is the part of the program that's always kind of depressing for me, particularly when I do these for students, because this quota is very limiting. It's very frustrating for students. It's very frustrating for universities, very frustrating for U.S. employers, but the quota is not going anywhere. It's been around for a very long time. I certainly don't see it changing anytime soon. So what I usually encourage students is, look, you're an international student. You need to plan ahead. Always plan ahead. Plan ahead when you're in your last semester of your degree program to get that OPT. While you're using OPT, plan ahead to get that H-1B registration in. If you're lucky enough to get selected, you get the H-1B, then you can start planning ahead with regard to the permanent resident green card process. And with that, I'm going to turn it over to Mary Ann or to Britt for questions.
Mark, great information. Always wonderfully informative. I want to just have a personal follow-up on what you just said, is plan ahead. And plan ahead must always mean, for any student, whether you're international or not, plan ahead and have multiple options, not just one egg in your basket. It's clear that this is not the visas that Mark has just been referring to are not going to be an option for perhaps the greater number of international students in the United States today. So have not only plan ahead, but have alternate options. I want to remind you about the GoinGlobal career guides. Very informative for students who end up having to return home, who have to return to another location. I also want to remind you that we have 47 U.S. city career guides with lots of information on various locations throughout the United States. Mark, I will start with a question that I'm always asked, and be happy to hear what you have to say. A lot of a great majority of the job postings out there on job boards in the United States or an employer website will say that particular employer does not sponsor visas. If it says that, then what's a student to do?
Well, and that is a very common issue. And what I encourage international students to do all the time is branch out. You have to broaden your search. What I find is that many employers, particularly ones who are the larger employers in the United States, they can actually, they have access to all the top US candidates. So many larger employers actually have policies that they don't want to sponsor H-1B. They can get plenty of US candidates. They have no need to sponsor H-1B. It's the smaller to mid-sized companies, the companies that have maybe 250 or fewer employees, that are very willing and open to sponsoring H-1B. And the reason is they often don't have access to the top US candidates because they're off going to Wall Street or some of the larger companies. But the smaller to mid-sized employers do have access to the top international grads. And so they are willing to sponsor H-1B. So I encourage students all the time, don't just look for jobs for employers that are recruiting on your campus. Broaden your search and look for employers in all kinds of different locations, particularly smaller to mid-sized companies in your particular field.
Great recommendation. Britt, have any questions come through on the chat? I know we don't have a lot of time left, but please go ahead, Britt. Any questions? I've got more here if you have not have come in.
Gotcha. So there's a concern regarding students in OPT if they can't find a job and they're worried about using unemployment days. Do you recommend that a student volunteer for an organization until they can find a job to hold off accruing unemployment days?
Well, I mean, so once the optional practical training work card becomes effective, the student has 90 days of unemployment time. So first strategy for the student to consider, if they're in the last semester of their degree program and they're applying for OPT, they don't yet have a job offer, they can make that card effective anytime within the 60 days after graduation. So it may be that they want to make the card effective. Let's say they graduate May 10. So they can make that card effective anytime up until July 10, 60 days afterwards. So maybe they want to make the card effective 30 days after graduation. That 90-day unemployment clock does not start to tick until the card is effective. So by delaying the effective date by 30 days, they bought themselves additional time to find employment. But the risk of that is if they get a job offer during that initial 30-day period before the card's effective, you can't go to work until the card is actually effective. So they may lose job opportunities. So it's a very hard decision for international students to make, and I encourage them to talk to their foreign student advisor to kind of work through those issues. But if they have the card and it is effective and they have not found employment and the 90-day clock is ticking away, can they go to volunteer for an organization to stop that unemployment clock? The answer is they can if they don't have any other options. I mean, if that's the only option they have, then do it. The problem is that the volunteer work must be related to their degree program. And in most circumstances, the employer is taking a risk, frankly, by having the student work as a volunteer, because in the United States of America, you're supposed to pay your employees unless it is truly charitable work that they're volunteering for. If the student goes to work volunteering in a job that the employer is paying other people to do, that employer is running the risk that the Department of Labor is going to come in and say you should have been paying this international student as well. So they can go to work as a volunteer, but there are some caveats to that.
Britt, I say that we have time for 2 more questions. I do want to remind everyone on the call that because you are a customer of GoinGlobal, Bill and his colleague, Crystal Malik, who will be joining us for the next session, are happy to answer your questions with their compliments. This is an extraordinarily generous offer on their part. We remain grateful for that. So if your question does not get asked and answered today, please reach out to Crystal and Mark. But Britt, 2 more questions and then we'll wrap it up.
Yeah, Mark, can you talk a little bit about O2 visa? Someone's saying here that many of their grads have pursued that O2 visa.
Well, the O1 is for individuals who have extraordinary ability. O2 is for support personnel who work for individuals in O1 status. If you have a particular issue with regard to, my office, we process many O1s and then O2 from the support personnel. If you have particular questions about it, I would encourage you to send me an email or give me a call. I'm happy to discuss.
So that kind of leads into a next question is university international staff. They'd like to know more ways they can continue getting trained in these matters other than attending our webinars.
Well, probably the most effective organization for individuals who are in international student offices at universities is NAFSA, the National Association of Foreign Student Advisors. NAFSA has outstanding resources available to individuals who work with international students. They also have an excellent, they have many regional conferences and they have an excellent national conference. But they also have many informational webinars and things like that that are specifically geared to international student offices.
Okay.
Well, with that great recommendation, this is Marianne Thompson again. We're going to wrap this up. I do want to remind everyone this session has been recorded. You should be able to access the recording by tomorrow. You'll get a letter from GoinGlobal that also has the link embedded. Please remember to join us for yet more valuable information on March 19th when Mark and Crystal will be hosting and sharing their expertise with your employers. This is a combination gift from Mark and Crystal and GoinGlobal. So remember, you will find a sample email invitation posted on the GoinGlobal website when you access the page that has the information for our Visa webinars. There is a sample invitation pre-written for you to use that, again, has the registration link embedded in it, so your employers, folks that you choose to invite, can directly register and hear much more about this topic. I've had the honor of participating in these webinars for almost 2 years. You can't hear this information enough. So I will tell you, just because the information on March 19th says it's for employers, it will be a lot of the same information, and this information is a challenge. It's difficult, and I think the more you hear it, the more you'll understand. So with that, thank you, Mark, yet again. Great job. My colleague, Britt Martin, thank you for taking us through the presentation today. And thanks to all of you who are GoinGlobal customers. We appreciate your business and your support and appreciate the time you've taken to join Mark this afternoon. All the best from GoinGlobal. We're signing off here. Goodbye.